The Sixth Amendment says, quote, "In all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense," unquote. The right to a lawyer isn't just for the popular or the innocent. It's for everyone. John Adams defended the British soldiers accused in the Boston Massacre. It was 1770. The colonists were furious. The soldiers had fired into a crowd, killing 5 Americans. Adams took the case anyway. He believed something that would become fundamental to American law. Everyone deserves a defense. Everyone. Even the despised, even the guilty, even the enemy. He won acquittal for most of them. He was attacked for it, and he called it, quote, "one of the best pieces of service I ever rendered my country," unquote. Fast forward 255 years, the Trump administration issues executive orders targeting law firms for the crime of representing clients the president doesn't like. Every single court that has reviewed these orders has found them unconstitutional. Every single one. I'm Sera, this is Ethos Trek, and today we're examining what happens when the government decides that some people don't deserve lawyers and goes after the lawyers who disagree. In early 2025, President Trump signed a series of executive orders targeting specific law firms, not for committing crimes, not for ethical violations, for representing clients. The firms targeted were some of the most prestigious in the country. Perkins Coie represented the Democratic National Committee and Hillary Clinton's campaign. Jenner and Block represented clients in election-related litigation. Wilmer Hale, former special counsel Robert Mueller, was a partner there. Sussman Godfrey represented E. Jean Carroll in her defamation case against Trump. The executive orders directed federal agencies to review these firms' security clearances, their government contracts, and their relationships with federal entities. The message was clear: represent disfavored clients and we'll come after your business. The orders used vague language about, quote, weaponization, unquote, of the legal system and protecting the country from firms that allegedly abused legal processes. But look at the actual trigger. These firms represented people and organizations that opposed President Trump. That's it. They did their job, providing legal representation to the quote-unquote wrong clients. These executive orders didn't survive judicial review. In fact, they were struck down unanimously across multiple courts and multiple judges, including judges appointed by both Republican and Democratic presidents. Judge Beryl Howell for the Perkins Coie case. Judge Howell, an Obama appointee, ruled that the executive order targeting Perkins Coie violated multiple constitutional provisions. The First Amendment. The order violated freedom of speech and association by punishing the firm for representing disfavored clients. The Fifth Amendment. The order violated due process, punishing the firm without any finding of wrongdoing. The Sixth Amendment. The order chilled the right to counsel by making lawyers fear retaliation for representing unpopular clients. Judge John Bates for the Jenner and Block case. Judge Bates, a George W. Bush appointee, granted summary judgment for Jenner and Block. meaning he found the constitutional violations so clear that no trial was even needed. He found the executive order was, quote, viewpoint discrimination, unquote, the government punishing a private entity for expressing views through legal representation. The president opposed. Judge Richard Leon for the Wilmer Hale case. Judge Leon, another George W. Bush appointee, also granted summary judgment. This is notable because Judge Leon has often ruled in favor of Republican administrations, but here he found the constitutional violations undeniable. When judges appointed by presidents of both parties unanimously agree that the action is unconstitutional, that tells you something about how far outside constitutional norms it falls. Why does this matter? The right to counsel. The Sixth Amendment guarantees the right to counsel, but that right is meaningless if lawyers are afraid to take cases. Think about what these executive orders communicate. If you represent someone the president doesn't like, we'll review your security clearances. We'll pull your government contracts. We'll investigate your firm. How many lawyers will take that risk? How many firms will accept politically unpopular clients, knowing the government might retaliate? The chilling effect is the point. You don't have to actually destroy every firm that represents your opponents. You just have to make enough of an example that others are afraid to try. The First Amendment. Legal representation is a form of speech and association protected by the First Amendment. When you hire a lawyer, you're speaking through them. When a lawyer takes your case, they're associating with you. The government cannot punish people for their speech or their associations, even unpopular ones. That's the whole point of the First Amendment. It doesn't protect popular speech. Popular speech doesn't need protection. It protects the speech that the majority wants to silence. The rule of law. Our legal system works because everyone, even the government, plays by the rules. When the government loses a case, it accepts the judgment. When someone sues the government, they can get a fair hearing. If the government can punish the lawyers who beat them in court, that system breaks down. Who will sue the government if doing so means retaliation? Who will defend the people the president accuses if lawyers themselves become targets? There's a broader pattern here. The law firm targeting doesn't exist in isolation. It's part of a pattern using executive power to punish perceived enemies. Other targets have included universities, institutions that criticized administration policies, or harbored protest movements have faced federal funding reviews and investigations. Media organizations, outlets that publish critical coverage, have been threatened with regulatory action. Individual critics, private citizens who criticize the president on social media have been subjected to IRS audits and other federal scrutiny. The message is consistent. Oppose us, and we'll use the power of the federal government against you. This is the authoritarian playbook. Scholars who study authoritarianism recognize this pattern. Targeting lawyers is a classic move. If you can ensure that your opponents can't get legal representation, you can act against them without constraint. Every authoritarian government does this. Russia, China, Turkey, Hungary, they all go after lawyers who represent dissidents. opposition figures, and unpopular clients. The United States has been different. John Adams defended the British soldiers and became a founding father. Defense lawyers who represented accused terrorists were not punished by the government. Even the most hated defendants got legal representation. These executive orders represent a departure from that tradition. Ready for some critical thinking questions? Because that's what we do here. 1. If representing disfavored clients can trigger government retaliation, who will represent them? Public defenders are already overwhelmed. Elite firms can absorb some risk. But what about mid-sized firms that can't afford to lose government contracts? 2. What's the difference between holding lawyers accountable and punishing them for their clients? Lawyers can be sanctioned for ethical violations, for filing frivolous suits, for actual misconduct. None of that happened here. These firms were targeted for winning cases. 3. Does it matter that judges from both parties found these orders unconstitutional? In a polarized time, unanimous judicial agreement across ideological lines is rare. What does it tell us when it happens? 4. Could you be next? Today, it's elite law firms, but the principle extends to anyone who associates with, speaks for, or supports people the government disfavors. Where does it end? 5. What does John Adams's example teach us? He wasn't punished by the colonial government. He wasn't stripped of his practice. He went on to help found a nation. What's changed? What can you do? Well, 1, support bar associations. The American Bar Association and state bar associations defend the independence of lawyers. Their voices matter. 2, contact your representatives. Ask what they're doing to protect the right to counsel. Ask if they support legislation protecting lawyers from retaliation for representing unpopular clients. 3, understand the stakes. If you ever need a lawyer to defend you, to sue someone powerful, to protect your rights, you need lawyers to be willing to take your case. That willingness depends on knowing they won't be punished for it. 4, support legal defense organizations. Groups like the ACLU, the Lawyers Committee for Civil Rights, the National Association of Criminal Defense Lawyers are on the front lines. 5, know your history. The right to legal counsel has been defended across American history. Learn that history. Share it. Make it impossible to forget why it matters. Here's what we know. The Trump administration issued executive orders targeting law firms for representing disfavored clients. Every court that reviewed these orders found them unconstitutional. Judges appointed by both Republican and Democratic presidents unanimously agreed. The government cannot punish lawyers for their clients. The constitutional violations include the First Amendment, freedom of speech and association, the Fifth Amendment, due process, and the Sixth Amendment, right to counsel. John Adams knew something we're in danger of forgetting. The adversarial legal system protects everyone. When lawyers are afraid to defend the unpopular, none of us are safe. Because popularity is fickle. Today's insider is tomorrow's outsider. And when you're the one who needs a lawyer, you'll want someone brave enough to take your case. In our final episode of this series, we'll bring it all together. The Supreme Court's immunity ruling, the accountability gap it creates, what happens when a president cannot be prosecuted for quote-unquote official acts, even if courts find those acts illegal, and what you can do about it. Above the Law, the immunity question is next. I'm Sera. This is Ethos Trek. Stay informed, stay engaged, stay constitutional. Thank you for listening to Ethos Trek. If you like this content, please like this video. Consider subscribing. Leave a comment. If you think someone else might enjoy this content, please share.